Good morning, everyone, and welcome. Today is Wednesday, October 23rd, 2019. This is the time for the regularly scheduled meeting of the Utah Board of Oil, Gas, and Mining's October meeting. My name is Mike Brown, acting chair of the Board of Oil, Gas, and Mining. I will be chairing the meeting today on behalf of Chairman Gill, who was not able to attend our meeting. I would like to remind everybody that these mics are physically actuated with your finger. Please turn them, get as close to them as possible so that the reporter can hear and record things. The first item on the agenda today is docket number 2019-019, cause number 139-166. in the matter of the request for agency action of Axia Energy 2, LLC. We'll take appearance of counsel at this time.
David Bolda with Beatty and Wozniak on behalf of Axia Energy 2, LLC.
Gordon Rowe with the Utah Attorney General's Office representing the division.
Thank you. Mr. Bolda, please proceed.
Thank you, Mr. Brown, members of the board. At this time, I'd like to introduce my witnesses and ask that they be sworn in at this time.
Please.
Okay. Have Leslie Gadd to my right, and Taryn Frenzel on her right side, and then behind us, David Schmoody. Again, if they could be sworn in at this time, that'd be great.
Thank you. Please proceed.
Will you raise your right hands? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you.
As has been the traditional practice of the board, I'd like to confirm that it's acceptable to move for admission of the exhibits at the end of the presentation.
That is our preference. Thank you.
Okay. So this request is to create two 1,280-acre spacing units. These subject lands are located primarily in Duchesne County, with a small sliver in Uintah County. They're just north, and we'll have some slides that'll depict this, but they're just north of Axia's previously approved spacing unit or spacing order in cause number 139-138, and adjacent to one of Axia's other spacing orders in cause number 139-149. The exhibits and testimony that you're going to hear today are going to be very similar, if not the same, as was presented in those matters. You'll also see that these are the only two 1,280-acre units within this township and range that have not been spaced for long lateral horizontal drilling. Everything surrounding it has already been spaced. These are kind of the last two holdouts. There was some ownership that was recently exchanged in these lands that allowed Axia to move forward with that. So a granting of this request would make these two units comparable to the others within this township and range. Notice of this request and this hearing was sent via U.S. mail to all owners in the area where spacing is sought, and to all administrative agencies having jurisdiction over the lands where spacing is requested. They were mailed to the last addresses disclosed by the relevant state and Duchesne and Uintah County Realty records, and by Axia's internal records. Notice was also published in the Salt Lake Tribune and the Deseret News on October 6th, 2019, and in the Uintah Basin Standard and Fernal Express on October 1st, 2019. No responses have been filed, and the division did not submit a staff memorandum in this cause. No other responses to the request were filed. No other appearances have been made. I'd now like to go to my first witness, Miss Leslie Gadd. And can you please state your name and business address for the record?
Leslie Gadd, 1805 Shea Center Drive, Suite 400, Highlands Ranch, Colorado, 80129.
And your current position with Axia?
I'm a senior landman.
Can you briefly discuss Axia's corporate and bonding status?
Yes, Axia is a Delaware corporation in good standing and duly qualified to conduct business in the state of Utah. We're fully bonded with all of the state and federal and Indian agencies.
Thank you. I want to point out that Exhibit A contains the statement of qualifications for the witnesses. We won't go through all of those now. And Exhibit B, which I'm not going to put up on the screen, was the prior spacing order related to these lands, a full copy of which was submitted with the exhibits. I'd like to turn your attention now to...
Just a moment. I do not see Leslie's in Exhibit A.
You've got Rick on there, David.
Yeah, we had originally planned on having Rick testify. He was unable to make it, and so Leslie is testifying in his place.
That's fine.
That's fine, but she is not in Exhibit A, which is...
Okay, I have it up on the screen, but I will submit that for your so that it becomes a part of the record. Exhibits, Ms. Gadd, exhibits C, D, E, and F. Were these prepared by you or with your input and review?
Yes, they were.
Okay. So we have Exhibit C on the screen. Can you please explain this exhibit?
This is just showing, is this on? Where, in relation to the state of Utah, actually, we're requesting this for the Butcher Butte area, right there on the border between Duchesne and Uinta counties.
Okay, thank you. We'll turn now to Exhibit D, and can you please explain this exhibit?
Yes, this is the exhibit showing the 4 sections that we want to include in the 1280 spacing, 16 and 21 and 15 and 22.
Okay, and there are some existing wells on these lands, is that correct?
Yes, that's correct. There's, 4. One saltwater disposal well that Altamont continues to operate, and then actually has 1 well in Section 21. All the other wells are owned and operated by Altamont.
Okay, thank you. Turning now to Exhibit E, can you please explain this exhibit?
This is showing you where all the other spacing orders were approved and the cause number of each one of them, and the date in which they were approved, or the month and year that they were approved. So you can see these sections are sitting out there sort of all by themselves.
Okay. Within, to clarify, these other causes, spacing orders surrounding the subject lands, they contain the same setbacks that we're requesting here today, correct?
Yes, that's correct.
Okay. Turning now to Exhibit F. Can you please explain this exhibit?
Yes, this is showing you the 4 sections that are involved in today's hearing, and primarily they were fee ownership. There were some state of Utah, the Utah School and Institutional Trust Lands Administration, but most of it is fee.
Okay, and so the dashed red line shows the area of notification, the people
Correct.
within which you provided notice.
Correct. We actually got, from our old spacing, we looked at those when we did the buffer zones from our other spacing, along with our revenue deck from the well we operate, and Altamont shared their ownership as well. So, and then we did county checks as well.
And then the reason there's no buffer zone surrounding these lands is because the setbacks that we're requesting here today are already approved in the surrounding lands, correct?
Correct.
Okay. I now want to show Ms. Gadd the certificate of service, which is a pleading already on file. Do you recognize the names on this list?
Yes.
Okay, and who are they?
These are all the owners that we found of record in Uinta, Duchesne, in Axia's records, Altamont's records, and previous spacing. So we looked at multiple sources in order to gather that list of names.
Okay, and partially based on title opinions?
Oh, yes, absolutely.
And the search of the county records prior to
Yes.
filing this request.
Every well has a title opinion, so those names that we got from Altamont and that we are dispersing on all came from title opinions.
Okay, and these would be considered business records of Axia?
Yes.
Okay. So this concludes my examination of Ms. Gadd.
Division?
Yeah, I just have a couple questions. First, it might not be apparent from the exhibits, but these 4 sections lie under the town of Roosevelt, Utah, and I was just wondering if there's any special precautions that you feel are necessary in protecting the town and any issues with locating adequate surface locations.
Well, I'm sure that Axia will take every precaution in making sure that they are working with the people on the ground and placing their pads in a place that's not interfering with anything else. We do know it's in the town, and we're very aware of that, so we're going to be extra careful.
Great, great.
I'll just add, there's 4 other wells in this area already, so it's not unknown, and pads are there already.
Yep. Okay. That's all I have. Thanks.
Board members, questions for this witness?
Sorry.
Oh, go ahead, Gordon.
Mr. Moon, please.
Who names your wells?
None of the people here.
Okay.
We were talking about that on the way over here, like, oh, who names these wells?
I'm sure there's some coordination to the location, but boy, have you considered?
Tried, Karen?
Have you considered maybe adjusting? You're on a roll here with Butcher Butte. I don't want to. It's just out of curiosity. It's not.
It has to do, and it's not me, but it has to do with having 5 zones, and they each have 8 slots, so is it this one over and this one up, so that you get 32 or 40 wells named properly, so they have their own place.
Okay.
Like row 1, up 4, that type of thing, so.
You're going to stick with Butcher Butte, though. You like that.
Apparently.
That part we'll stick with.
Okay.
Ms. Davis?
In previous hearings, we've seen kind of what the overall ownership of the lands in question are. What's the overall ownership of Axia and other parties in these 2 sections, well, these 4 sections?
I don't actually have the working interest list of the other working interest owners. Altamont originally had these lands, and we traded them. So Altamont has reserved the well bores in those wells that I explained that were in 15 and 16. And so we took the information they had, and we are now using that for this hearing. But we don't have anything to do with those wells, so I really don't know who the working interest owners are that they have in those wells. But they gave me the list, so those people ended up on the list of notifications.
Right. The reason I ask is you're asking for, was it 40 wells? 32 wells in this area, and we have recently been considering parent-child interactions with wells. If the property is owned almost exclusively by Axia, that's not as big of a deal, although we are tasked with making sure we get as much oil out of the field as possible. But if it is other parties, and there are 4 other wells here that could be affected, it becomes more of an issue if you're taking oil and gas from those wells. Are they currently operating, those wells that are there?
Altamont is. That was part of the trade, that they would keep those well bores and operate those well bores. And Altamont, now Axia, was and is the majority working interest owner in those 4 sections.
Other questions? Please call your next witness, Mr. Bolden.
Mr. Schmoody, can you? Okay, can you please state your name and business address for the record?
David Schmoody, 1805 Shea Center Drive, Suite 400, Highlands Ranch, Colorado, 80129.
And your current position with Axia?
VP Geology.
Okay, and Mr. Schmoody has been recognized as an expert in geology in a number of matters before the board. I believe most recently in cause number 139-153. His statement of qualifications has been submitted as Exhibit A in this cause. So with that and the division's consent, unless the division has any concerns, we would like Mr. Schmoody recognized as an expert in geology for purposes of this cause.
Mr. Rowe, any objections?
No objection.
Board members, any objections? Hearing none, he is recognized as an expert witness in the field of geology for purposes of this hearing.
Thank you. Mr. Schmoody, I have here exhibits G, H, I, and J. Were these prepared by you or Axia personnel with your supervision and review?
Yes.
Okay, let's turn now to Exhibit G. And can you please explain this exhibit?
Yeah, Exhibit G is a 2-well cross-section across the area, including and or near the application lands, that shows the stratigraphic nomenclature used, as well as the proposed horizontal spacing order interval and the continuity of those stratigraphic units across the area.
Okay. Exhibit H, could you please explain this exhibit?
Exhibit H alludes to, was mentioned earlier, I guess by Taryn, about the multiple intervals that we are currently drilling horizontal in. We have drilled 6 primary targets that are stacked. We have identified a total of 8 potential targets, but have drilled to date 6 of those targets across the lands. The diagram type log on the right shows the breakup of those different frac zones, as we call them. And the highlighted ones, or the green highlighted ones, are the 6 intervals that we have already drilled horizontal wells and producing from currently. And the acreage in question today, the 2 spacing units, is prospective for all of these intervals.
Thank you. Turning now to Exhibit I. Can you explain this exhibit, please?
Yes, Exhibit I is a zoom in on the existing well bores showing the stratigraphy in the 2 spacing units specifically. Once again, showing the continuity of the reservoir bodies that we will be targeting, and that they are continuous across the area, and as I mentioned a minute ago, are prospective for the 6 intervals that we've been drilling thus far.
Thank you. Finally, Exhibit J.
Exhibit J, we've shown before. This is a snapshot showing our petrophysical model and how we derive our resource in place numbers for our different frac intervals or horizontal intervals. On the right is a map showing the location of the wells that are used in that petrophysical model. that is then propagated across the whole project area, where it gives us certainty around the resource in place that we will be targeting, and that Taryn will talk a little bit about when we get to the engineering side of things. But just a quick slide to show the petrophysical model used across the project area.
Okay, thank you. In your expert opinion, will a long lateral horizontal drilling program within the subject lands result in greater resource recovery and less waste?
Yes.
This concludes my examination.
Thank you, Mr. Bull.
We don't have any questions for this witness. Thanks.
Board members, any questions? Seeing none, please call your next witness. Mr. Bolda.
Okay, Mr. Frenzel. Can you please state your name and business address for the record?
Taryn Frenzel, 1805 Shea Center Drive, Highlands Ranch,
And your current position with Axia?
VP of Completions and Engineering.
Taryn has previously been recognized as an expert in engineering and prior spacing requests and in compulsory pooling requests, most recently in cause number 139-156. His statement of qualifications have been submitted as Exhibit A. With the consent of the division and the board, would like to have Mr. Frenzel recognized as an expert in engineering for purposes of this cause.
No objection.
Board members? Seeing none, he is recognized as an expert in petroleum engineering, or just engineering, you said?
Petroleum engineering.
Petroleum engineering for purposes of this cause. Thank you.
Okay. Mr. Frenzel, you have exhibits K, L, M, and N in front of you. Were these prepared by you or with your input and review?
Yes.
Okay. We'll turn first to Exhibit K. And can you please explain this exhibit?
Yeah, this represents our expectations by zone. As you can see, for instance, in the Uteland Butte, we have 290 feet of net, 6.7% porosity. Saturations of 80% oil on a 1280 basis. That's 112 million barrels of oil in place at 10% recovery and 8 wells per. You're looking at a 1.4 million barrel well, which is a 78% rate of return. You can see it varies by zone. We've done 25 wells to date. Everything matches these very nicely. We're anywhere from 24% up to 108%, which definitely meets our expectations on rate of return.
Thank you. Turning now to Exhibit L, can you please describe this exhibit and what it represents?
Yeah, this describes our pattern based on microseismic in the area. We believe everything to be 660 spacing. We'll do this on a staggered pattern. What this means is every zone that you move up, you move over 330 feet to minimize any hydraulic interference vertically from the wells. Along with that, as in approved, dockets 131-141 and 139-134 will be no closer than 330 foot laterally within the same zone from another perforation. And then lastly, as we move up into the zones, as long as we're 100 feet above our lateral, there will be no interwell setbacks on that particular zone.
Okay, and Ms. Davis brought up a question earlier about existing wells and protecting essentially the integrity and the production from those wells. Here you just discussed, and it's on this exhibit, that we've requested a 330-foot setback from those wells. Is that consistent with all of Axia's other spacing orders and the spacing orders in and around this area from other operators?
Yes.
Okay, thank you. Moving on now to Exhibit M. Can you please explain this exhibit?
This just shows all the data we have about orientation in this particular area on the east side. You can see we're north 61 degrees west as an average for this area, and that's what we'll be using for our setback calculations.
Okay, and finally, Exhibit N. What is this exhibit?
Yeah, this is requesting 330-foot north-south setbacks, which is consistent with the other dockets in this area, and 560-foot east-west setbacks. Again, based on microseismic with 311 feet of half length at 61 degrees, you can see we're still 288 feet from the west line and 179 feet from the south line, protecting correlative rights.
Okay. In your expert opinion, do you believe that long lateral horizontal wells on a 1,280-acre drilling and spacing unit will protect correlative rights and prevent waste?
Yes.
This concludes my examination of Mr. Frenzel.
Thank you, Division.
With your permission, I'd like to turn it over to division staff for a few questions.
Please.
Yeah, Dustin Doucette, Petroleum Engineer for the division. If you could turn to Exhibit L. So on kind of the cartoon diagram here, you have the offset wells 660 feet apart and in the same zone, although you're asking in this request for up to 330-foot setbacks. Is that correct?
That's correct. We won't be any closer than 330.
Is your plan to get closer than 660 feet, or is it going to be more based off of this cartoon?
Based on our information and data right now, we believe it's 660 spacing, and we'll not need to get closer than that in our spacing.
Okay, and if you'll go to Exhibit N. And you'd mentioned this data was generated off of microseismic data, is that correct?
Yeah, that we're showing in 139, 129, that the exhibits are here of where that microseismic is shown in previous.
And do you know which zones, like out of the 8 zones you're interested in, which zones those were, that microseismic data was generated in?
I'm pretty sure it was an average between a Uteland Butte and a Wasatch. I think there's 2 Uteland Buttes and 1 Wasatch.
And so is that pretty consistent of what you think this will be across those entire 8 zones?
We've done lots of modeling internally, matching those, and then taking them to our other zones to understand geometry. Yes.
And just one final question, I guess. So if this is 330 setback from the toe, then does that more support a 660 setback, kind of like you testified is what your thinking is between wells? You'd have a 330 between there and then a 330 from the other well on the other side of the section?
No, well, it'd be a 330 from, is your half length, right?
Right.
So not 660 would be the whole distance, so that'd be 622 feet is the expected full length of that particular wing.
Correct. So it wouldn't be necessarily 330 between wells based off of your data here. It would be maybe closer to 600.
Well, it's suggesting that if I'm 330 away, then I should be okay to put a wellbore there.
From the section line, I'm just saying from another well and their frac half length, it would be more than 330. Could be more than 330
It could be. It could be.
Okay.
Generally, all the vertical wells out here are not fracked and are different horizons, so they may be an acid job, something like that. It isn't draining anything.
Okay, thanks.
Could you go back to Exhibit L? As you look there, let's say
John, could you please identify yourself?
John Rogers, Associate Director of Division of Gas and Mining. As you look at, say, the carb marker zone, are you asking for a lease line well in this?
Nope, that's just represented. That will need to be done at some point.
Okay,
We're not asking for that today.
Not asking in this.
But we
Okay.
wanted to fill in the blanks.
Okay.
No further questions from the division.
Thank you. Board members, any questions? Ms. Davis.
This is for both Dustin and John. As you look at this, do you have concerns about the parent-child relationship in that many wells in these sections?
This is Dustin again. I mean, I think in the 1280, I think since it's getting spaced, I think it's in the operator's best interest not to get these too close to one another. So everybody will be sharing equally on those. I mean, there is maybe some concern getting too close to a vertical well, which is only sharing on a 640, and that has come up on occasion of how we administrate that. And definitely, I mean, we've seen drilling, vertical wells in particular. There definitely are zones that drain more than other zones, laterally extensive zones. The sands may drain further away than some of the other tighter formations. So, I mean, there are going to be some zones that have been produced a little bit more, but I think as far as the 1280s, the long laterals, I don't think there's a lot of the operators are going to protect themselves and make sure that they're not getting too close to one another, I think. And there's a little safety factor built in because they're preserving their minerals and their profit share on that. So, I mean, that's my comments, I guess. I don't know if John's got anything.
Susan, did that address your question?
So is it your view that this maximizes recovery from these sections, overall recovery?
I believe so. It gives them the flexibility. They're not going to go right out, I don't think, and drill 32 wells. It gives them the flexibility to kind of play with that. And I think it kind of self-polices themselves from getting too close. It may not end up being 32 maybe in the end, but they've got, I mean, the 32 I think is based off of maybe these 5 or 6 markers, and they've got 2 or 3 additional ones that they're interested in. So I think there is a buffer there as well. So I think it probably is protective of correlative rights and greatest resource recovery.
This is John with the division. When you say maximize, it's a tough thing to define, because if we artificially restricted them, then they may not produce enough. So it's going to take some time to analyze what they're doing here. So if we put something on them now, I think we could almost reduce what they're recovering through some artificial restraint. So I think it's the best thing to do is let them do what they need here and have them analyze and do the research.
And I guess there's one other comment on, I mean, we've heard testimony, about completing these more at the same time, doing zipper fracs, stuff like that, which can increase your recovery. So if we limit that to kind of like John was saying, of not giving them that flexibility and ability to, produce close enough or enough wells at the same time, that could inhibit, recovery of the resource as well. And definitely the economic recovery of the resource.
Other questions? Mr. Moon.
So the 660, have you had an opportunity to test that yet? Looking at your drilling right now, you're pretty much drilling, moving on.
We are.
What's the closest you have drilled, and have you gotten some feedback from having wells very close together?
Yeah. We have not done a spacing test. That's next. We're actually on a pad now drilling. Actually, the next 2 pads will be spacing tests. Done a ton of research just south of us. Newfield has done some 660 tests. It's very encouraging. I don't think Crescent Point has, but based on Newfield and our in-place models and our reservoir models, we believe it's still 660. We do have some vertical parent-child tests 400 feet away. It's not 330. You can definitely see an impact when we frack next to it, but pressure came all the way back down right to where it was. So it's like completely not interfered at 400 feet. So we're encouraged. And that's the Uteland Butte. We have 5 other zones. We don't have that data across all zones, but based on our other data, that's what we're thinking.
Thank you. Very informative. Other questions, Steve? If you're not done,
Well,
go ahead and finish, Gordon.
How much does pressure have to do with that? Because the further north you go, the more pressure you have. Does that indicate that you need to spread them more because there's more existing pressure there? How do you account for that? How much does that come into play?
Not going to be much. Pressure is there because of the seal. It's so tight it can't move anywhere, so it's generated and it's trapped right there. So moving north, we found that it's very similar pressure, actually, at least within our acreage play, the 3 townships. The gradient may be reduced, but the absolute pressure is about the same. So what happens in the north should be very similar to what happens in the south. We're not seeing differences there.
Okay, thanks.
Just a follow-up question on the units that you've already spaced. How close have the closest wells been in the same of those 6 zones that you have drilled?
We haven't drilled 2 of the exact same zones in any spacing unit yet. We're spreading out and getting data. Yep.
Other questions? Go ahead, Gordon.
So back on Exhibit J, this shows a vertical 300-foot frac zone, and it seems to show that 300-foot taking in both the Uteland Butte and the lower Castle Peak, but you're planning on drilling wells in the lower Castle Peak and the Uteland Butte, or explain the 300-foot here.
Our 300-foot is based on geometry and it's a microseismic, so that's the height growth that we're seeing on our fracs. That's what we expect to drain within that section. So our lateral is actually going through the Uteland Butte on the bottom there. That's identified, that lower purple, but we do know that we're fracking up into the lower Castle Peak. We do have a Castle Peak zone that's actually the next zone up, so they're different zones, even though they share similar names. Okay. So we always call them frac zones versus formation names.
Okay. So is there some pretty, I forget the name for it, but pretty clear delineators that hold those barriers?
Yeah. So that hot gamma ray right at the top, that's about where the fracs stop growing in the upward direction on this particular stage, and then growing down from the Uteland Butte again, it gets pretty shaly. A lot of carbonate-rich stuff on the right-hand side. Our dipole sonic shows that the Great Barrier going down within the Uteland Butte.
Okay.
Mr. Schmoody, did you have something else you wanted to add?
Yeah, the only comment I was going to make is there is some confusion on the naming of our frac zones. They don't always stay within a given stratigraphic interval. So as Taryn alluded to, the positioning of our frac zones is based on modeling and geometry that we see from completing the wells. And so sometimes it will go above or below, to your point, the Uteland Butte goes into the Castle Peak, but we call it the Uteland Butte frac zone. So the names are a little deceiving in that regard, and that they don't always follow the stratigraphic intervals. That was all I was going to add.
Thank you. Steve, go ahead.
When you drill a specific frac zone, whereabouts is your target within the frac zone? Is it in the middle of it, or do you stay in the lower and most of the frac goes up?
In general, we stay in the lower third, expecting our geometry to grow upwards.
Okay. Any more questions from the board members? Thank you, Mr. Frenzel. Mr. Boulder, we're back to you.
Okay, well, that concludes my presentation in chief. I just as a summary, Axia has gone out and these other spacing orders and they've done what they said they were going to do. They've been testing these. These are the only 2, again, 1280s within this township that haven't been spaced for long lateral horizontal wells. They're on an island, and what we're requesting is exactly the same as has been done in all the lands surrounding these 2 drilling and spacing units. Thank you for your time and attention, and I would like to move for admission of the exhibits A through N inclusive, and I will make one modification to Exhibit A to add Ms. Gadd's statement of qualifications that becomes a part of the record.
I don't think we have any cross on an admission of exhibits, do we?
No, I don't think so.
Okay. They are so admitted. Mr. Boulder, thank you.
Yeah.
So, board members, Do you want to entertain a motion at this point, or would you like to discuss this?
I think we can, do you need to talk?
I make a motion.
Well, just a second, Susan.
I'd like to talk about this just a minute before we make a motion.
Okay, we're off the record. We're going to take 10 minutes to talk about this, Mr. Bolda, if that's okay. Okay, we're back on the record. I would like to do a couple of things just to clean up a bit before we entertain a motion. First of all, Mr. Moon has one more question that he would like to ask. And then I would like to go to the division to see if you have a recommendation. And Mr. Bolda will come back to you if there's a need for you to readdress anything or re-summarize. Thank you. So Mr. Moon, please.
So these wells that you're planning in the same drilling unit that are going to be adjacent or closer, are you going to do those around 660 to test that, or are they, what is your plan there?
The Wasatch is going to be 5 wells per on the first, will be 5 wells per, I don't know that exact spacing.
A little more.
As a test. From that, we'll know exactly how much we're recovering from those 5 wells, and then we'll decide if we go 8 wells or 6 wells or 7 wells from that.
Oh, you're
data
going to
set.
do all 5 then?
All 5 under 1280.
Wow, okay. Cool.
In one zone.
Okay. And, you know, if you voluntarily want to share that information with us, we talked about asking for it, but that we don't want to. If, you know, as we, and in our horizontal rulemaking, we don't know if we're going to get into that detail. We don't want to leave a lot of flexibility, but it would be nice just to know that as you learn. Let us know.
Might also add to the point that was brought up, we are going to be staggering.
This is Mr. Schmoody.
We're going to be staggering the target for those Wasatch wells. So they won't all be landed in the exact same stratigraphic horizon. So we're going to offset about 100 feet stratigraphically within the 300-foot intervals.
Okay.
To hope that we optimize efforts of completing the entire frac zone.
Okay, good.
Division.
In general, the division is supportive of this request. Overall, we believe spacing protects conservation and protects the rights and expectations of mineral owners in the area. So with that, we express our support.
Thank you very much. So Mr. Bolda, anything else in summary?
No further comments or summary.
Okay, thank you. Board, I would entertain a motion at this point.
I'll make a motion that we approve the agency action as requested.
Is there a second?
I'll second that.
The motion before us is that we approve the agency action as requested. All in favor say aye. Aye. Any opposed? Let the record reflect the voting was unanimous in the affirmative. Thank you. Mr. Bolda, do you need some time for the next one to get ready, or are we?
If you could just give us about a minute, we should be good.
Why don't we take 5 minutes?
That works as well.
We're off the record. If anybody needs to use the facilities, please do so. We are back on the record. And for the record, I would like to note that Mr. Bolda has agreed to prepare the order for the previous docket item that the board approved. Our second agenda item is docket number 2019-020, cause number 139-167, in the matter of request for agency action of Axia Energy 2, LLC. We will now take appearance of counsel.
David Bolda with Beatty and Wozniak on behalf of Axia Energy 2, LLC.
And Steve Alder with the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Thank you. Mr. Bolda, please proceed.
I guess for the record, we should probably have our witnesses sworn in again for purposes of this cause, or yeah, we good? Okay.
Let's do that, please.
Okay. Leslie Gadd and Taryn Frenzel will be my witnesses for this matter.
Will you raise your right hands? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
I want to offer a summary of this matter here. Subject sections 21 and 22 of Township 2 South, Range 3 West were established as a 1,280-acre drilling unit in cause number 139-153, which was entered on April 23rd, 2018. A true and correct copy of that order was submitted as Exhibit B. In addition to the well that Axia currently plans to drill within this drilling unit, Axia has asked that an order granting this request also apply to any subsequent wells drilled in this drilling unit, with the stipulation that it be subject to Utah Code annotated 40-6-6.5 subsection 12 and any other implementing rules and regulations which are currently in development. I want to point out that there are some unleased interest owners who have been unlocatable. There are also some estates of deceased parties for whom compulsory pooling is sought. As will be discussed in Ms. Gadd's testimony, Axia has diligently searched for the potential heirs of these deceased parties and obtained leases where heirs could be located. However, until those estates are or have been probated, there's no way to definitively determine who the correct heirs are. So that's why we have some estates of deceased parties here. And that's why we're asking that those interests be pooled in case additional heirs are discovered or where they were unable to locate heirs of deceased parties. The testimony, I believe that the testimony and evidence presented today will establish that the regulatory requirements to deem the unleased and uncommitted working interest owners as non-consenting parties and to compulsory pool their respective interests as to the subject well and drilling unit have been satisfied. The statute authorizes the board to impose the terms of a joint operating agreement upon compulsory pooled parties to govern future operations as long as those terms are fair and reasonable. Axia has requested the board to adopt the terms of the JOA submitted as Exhibit E to govern operations with the compulsory pooled parties. The board has jurisdiction over this matter pursuant to Utah Code annotated 40-6-6.5. A copy of this request was mailed by certified mail to all interested parties within the subject sections and to the governmental agencies having supervisory jurisdiction, as evidenced by the return receipts collectively submitted as Exhibit ZZZ this past Monday. Nearly all identifiable locatable parties received a copy of the request. As to those parties who could not be located because their current valid address could be found or are potential heirs or devisees of the estates of the deceased parties, notice was published in the Uinta Basin Standard and utahlegals.com as indicated on the affidavit of publication, which is marked as Exhibit YYY, which was also submitted Monday. In addition to those two exhibits, we submitted an amended Exhibit 1, which removed some parties. Since Axia has continued to work with any individuals, any owners willing to lease or participate since the filing of the request, we had a few changes, a few parties to remove from the request. So that's amended Exhibit 1. And then because of that, we also had to submit an amended Exhibit G, which are the royalty calculations, because some additional parties have leased. So the royalty calculations, the average weighted royalty went up slightly. And so that was the submission, the filing on Monday. Notice of this request and this hearing was also duly published in the Salt Lake Tribune and Deseret Morning News on October 6th, 2019, and in the Uinta Basin Standard on October 1st, 2019. No responses were received from any notice parties, and the division did not file a staff memorandum. I'd like to turn now to my first witness. Can you please state your name and business address for the record?
Leslie Gadd, 1805 Shea Center Drive, Suite 400, Highlands Ranch, Colorado, 80129.
And your current position with Axia.
Senior landman.
Can you briefly describe Axia's corporate and bonding status?
Yes, Axia is a Delaware corporation in good standing and qualified to conduct business in the state of Utah, and we are fully bonded with all the appropriate state and federal agencies.
Thank you. We'll turn now to our first exhibit, Exhibit C. Ms. Gadd, was this exhibit prepared by you or with your input and review?
Yes.
Okay, can you please explain this exhibit?
So this is showing you where the 1280 spacing there for sections 21 and 22, 2 south, 3 west, are located in relation to pretty much our entire field over there in 2 south, 3 west. And it also shows the location where the surface is on the east side down there and where the bottom hole location will be on the west side.
Okay, thank you. We also have Exhibits D and Exhibit 3 to the request for agency action. Were those prepared by you or with your input and review?
Yes, they were. Well, except for the survey, the actual survey. The surveying company did that.
With your
Right.
input and review?
Right. Yes.
Correct. Can you, turning first to Exhibit D, can you explain what this exhibit depicts?
Yes, this shows an actual on-the-ground survey that a surveying company did showing the start of the location here on the east side and where the bottom hole location target will be on the west side of that 1280.
Okay, and explain this portion of Exhibit D.
These are all the tracks within sections 21 and 22 that had different ownerships. It was a lot.
And Exhibit 3 to the request for agency action. Can you explain that?
So in conjunction with the map you just saw, those tracks, that's the legal description for them, and the percent that tract contributes to the entire 1280.
And let's see. Okay. Now, how were the tracts determined and individual ownership within the subject sections determined?
Through title opinions.
And what are the effective dates of those opinions?
May 24th, 2019 and August 7th, 2019.
And then prior to the filing of this request, you conducted additional searches of the county records. Is that correct?
Yes, that's correct.
Okay. I'd like to turn now to amended Exhibit 1 and Exhibit 2 and asked if those were prepared by you or with your input and review.
Yes, they were.
Okay. Can you please explain amended Exhibit 1?
So this is a list of all the working interest owners that we either could not locate or did not sign an operating agreement or did not make an election or did not respond, along with any unleased mineral interest owners that we were unable to locate or identify in this case. So I don't know if it matters to you, but we started off with 29 working interest owners and got it down to 19. And we started off with 72 unleased owners and down to these 6.
Okay, and Exhibit 2, can you explain what this exhibit shows?
Yes, these are the states that we identified. And just so you know, the first 29 names on that list is one family. It's just multiple states that have gone down through the years. And then the next 4 is a family, the next 4 is a family, next 5 is a family. I know it looks like a huge list, but most of these are family related. And so it's really not as many people as it looks like because it's all from similar families.
And the names and estates of the deceased parties were compiled from the title opinions, correct?
Correct.
How did you try to locate valid addresses for the heirs of the estates and the parties that you're seeking to compulsory pool in this request?
So the title opinions always give us an address, but it's the last known address filed in the county, which could be 40 years old. So as soon as we get that, the first thing I do is check Axia's records to see if by chance that same party signed another lease and we're paying them on another well, so we'll have an address for them. If that's not the case, then we start doing the Google and the white pages and the people search. And oftentimes what we'll do is look at Find a Grave or Ancestry, or even, we have different resources that we use within, title opinions, maybe the same family name. Like if there's 2 halls and one we can't find and one we can, then we try to contact that one to see if they're related.
Thank you. I'd like to turn your attention now to Exhibit M and Exhibit O, and ask if these were prepared by you or with your input and review.
Yes, they were.
Okay. Can you please explain Exhibit M and O?
Yes, Exhibit M is a well proposal that was sent to the known working interest owners at the time that went out, that we had an address for.
And this is
I'm sorry, it's a proposal for them to participate in the drilling and completion of the well.
Is there a working interest owner, correct?
Correct.
Okay, and then Exhibit O.
Exhibit O were the unleased mineral interest owners identified by our title attorneys, and they were given the option to lease, to sell their mineral interest, or to participate as a working interest owner in the well.
Okay, and again, these are examples of each a offer letter to participate to a working interest owner, and a one for a proposal to lease or participate to an unleased mineral interest owner. Correct.
Correct.
And exhibits H through S, those contain the complete list of letters that were sent out, correct?
Correct.
Can you please speak to Axia's sort of process that even after filing this request? How did you continue to work with the unleased owners or non-participating working interest owners?
So the first letter that you see, that's April 2nd. I've been working since April 2nd to find all these unleased owners. And we've not stopped. We've been using every resource we have. We got a hold of one family member. We got addresses for others, but then some, that's my stepmother. I don't know where she is anymore. I don't know that we're ever going to find that person. That kind of thing. We've been working, myself and someone out of our Vernal office have been working incredibly hard to identify everybody here, which is one of the reasons it's taken us so long to even force pool. We didn't want to come with that many people. We were really trying to get as many interests wound up as we possibly could.
And this is evidenced by the fact that we submitted amended exhibits this past Monday, yes, which reflects additional parties that agreed to lease or participate or sell, correct?
Correct.
Okay. So Utah Code annotated 40-6-6.5 subsection 6 provides a compulsory pooled unleased owner is entitled to payment of the average landowner's royalty during the payout period. I want to turn now to amended Exhibit G. Was this prepared by you or with your input and review?
Yes, it was.
Okay. Can you explain what this exhibit shows?
That is every lease of record as of last Monday, I believe, that's ever been recorded with the acreage, the net mineral acreage, and the royalty in the lease so that we could come up with our weighted average in both sections, 21 and 22. It's quite a few. It's 500 in some leases.
Okay, and what is the average weighted landowner's royalty?
So after compiling this whole list, we came up with a weighted average royalty of 16.16326612.
Okay, and that is up slightly from the time that the original exhibits were submitted to the filing of this amended exhibit, correct?
Correct.
Okay, I'd like to turn now to Exhibit E. Again, the pooling statutes allow the board to adopt terms of a joint operating agreement to govern operations as between the consenting owners and the compulsory pooled non-consenting parties. Can you explain this Exhibit E, please? And
Yes.
Let me ask first, was this prepared by you or with your input and review?
Yes.
Okay. Yeah, please explain what this exhibit shows.
Okay, this is a typical industry norm to have a joint operating agreement. We're using the American Association of Petroleum Landman Form 610 here, and this would govern all the operations for any of the wells drilled in sections 21 and 22 to South 3 West with the other working interest owners as to how you pay your costs, whether or not you can non-consent. It's just really a guideline for what they can expect and what we can expect for operations.
Okay, and we are not showing the entire exhibit here, but we're going to point out a couple of important details from this. On this page of the exhibit, it contains the non-consenting penalty that AXI is requesting, and what is that?
This is really standard, the 100, 300. In fact, actually, the 300 is a little low. For this area, it's actually 400%. Most operators are doing 400, so it's 100 is very common. The second one can vary, but 300 is very fair.
So the 400% is what's been entered into with those who have voluntarily
Correct.
agreed to participate, correct?
Correct.
Okay. And this is this Exhibit E JOA is materially the same as the JOAs signed by the other parties that have agreed to participate?
That's correct.
Okay. We'll turn now to the accounting procedure portion of this JOA exhibit. Utah Code annotated 40-6-6.5 sub 4D Roman numeral 3 provides that the board may impose a reasonable interest charge. So can you explain this exhibit and the requested interest rate by Axia?
Yes. Again, this is a standard industry form that every JOA has. Excuse me. And basically what this does, it will set out the interest rate being prime, established in the Wall Street Journal, plus 3% as fair compensation for any party who's getting too far behind on their bills.
Okay, and the overhead charges are on this following page. And what are those?
Again, those are really standard charges for monthly operations, pumpers, roads, the various things that we have to do to ensure that that well is producing and everything's getting to market.
Okay, and these costs and charges, as you mentioned, are typical for those that were signed by participating consenting owners, correct?
Correct.
Okay, I'd like to now.
Mr. Bolda? Yeah. I'm confused. This is the second Exhibit C I have seen. I thought.
I'm sorry. So it says. So this says Exhibit C. It's Exhibit C to
The JOA.
to the JOA.
The JOA,
Yeah. So
I'm
the
sorry.
the JOA exhibit has
Makes sense. Thank
has
you.
exhibits. Yes. So I want to turn now to the certificate of mailing, which is a pleading already on file in this cause. Do you recognize the names on this list?
Yes, I do.
Okay, and who are they?
These are, excuse me, the unleased, the unleased owners that we couldn't locate, as well as any working interest owners we couldn't locate, or any working interest owners that has not made an election, has ignored our letter, or wouldn't sign a JOA.
And this also includes the consenting working interest owners as well.
Yes, it does.
Provide them notice, correct?
Yes, it does, so they know we were having this hearing.
Okay, and how was this list compiled?
I compiled that through our title examinations, through title opinions, and just research trying to find people.
Okay, thank you. Now I'd like to turn to Exhibit ZZ. Was this prepared by you or with your review and supervision?
Yes, it was.
Okay, what is this exhibit?
This is a notification that we sent out that we were having this hearing. So if any party wanted to come to object to anything, they would know when it was going to be and where it was going to be.
Okay, so it contains the return receipts confirming receipt of the copy of the request by the locatable parties, those for whom you have valid addresses, correct?
Correct.
Okay, and now Exhibit YYY. Can you explain what this exhibit is?
Yes, this is an art. We have published this in the Uinta Basin Standard. So it's a publication that was filed on September 10th, 2019. That basically we put it in the newspaper so anybody who we may not be able to locate might see this and contact us, or even a relative who saw that might contact us. So it's just giving a public notice that this hearing was going to take place.
And are you aware of any anybody that responded to this publication?
No, no one.
Okay. Thank you. This concludes my examination of Ms. Gadd.
Sorry.
Thank you, Mr. Bolden, Ms. Gadd, for that efficient tour through all those exhibits. I really only have a few questions, and then I'll see if the division has any questions. But my main questions are a little confusion about Exhibits 1 and 2 as they were revised. And I tried to compare quickly Exhibit 1 as it was filed with Exhibit 1 as it's been revised. Mm-hmm. And it appears to me to be pretty much the same. Could you identify either on the revised or the original who you leased? And before we get to that, let me...
Got it right here.
When it says WI unleased, WI stands for what?
Working interest.
And what is a working interest?
That means that they appeared of record in the county as being a lessee under one of those 500 leases or multiple of those 500 leases.
Thank you. And then it says tract, but each of these doesn't have a tract. You've just listed a unit. Why is that?
Well, that's the percent that they would own in the 1,280.
No, I'm referring on Exhibit 1.
Right.
It's in the whole unit.
Right. I'm sorry. The percent of the unit is their tract that contributes to the unit and their interest in those tracts that contribute to the unit.
I think I understand that, but the exhibit itself doesn't include any indication of what tract they own. It just says unit for some reason. Do you see?
You're correct. That does not have a tract-by-tract breakdown of every owner in each tract. That would be a whole nother book of an exhibit. What this is trying to explain or show who's a working interest owner, who's an unleased mineral interest owner in the 1280 that we're requesting, and what percent they would own in the 1280 and therefore in the wells we drill within that 1280.
But the percentage itself wasn't included in this exhibit, as that is confidential information at this time, right?
Correct.
Okay, thank you. So on my Exhibit 1 that was filed with the request for agency action and the amended Exhibit 1, can you identify for us, it looks like Sabine oil was removed.
Correct.
Don't see too many, and maybe Mountain Oil and Gas.
No, Mountain Oil's still on there. You want me to read them to you? I'll tell you.
Can you just tell us?
I have a
tell the
list.
board- Tell the board which ones you were able to lease.
Well, that's good.
I'm mostly interested in knowing, just so that we have a complete record as to who is being force pulled,
Okay.
and also how effective your efforts were that you indicated you have continued to make to lease with people. So as to the working interest owners only, who was removed?
Sabine Oil and Gas sold to Axia. JC Petroleum, I believe, showed up as a unleased interest. They leased to Axia. The Brinkman, there were two Brinkmans. One was the estate of Virginia and the other one was the Sun. They both leased to Axia. Mountain Oil elected to participate and signed a JOA.
Okay, you're including the mineral owners as well at this point.
Well, yes, I mean.
That's good. Go ahead.
Okay. Then Slover Minerals leased to Bright Rock. Holly Hansen leased to Axia. There was one heir that I found for Howard R. Dustin, and she actually sold her mineral interest to us. And then 4X Holdings has been removed. 4X Resources is still on there, but 4X Holdings sold to WEM.
They were participating interest owners, so that was only changed. They were on there.
Okay.
I just want to point out that the motion for leave to file the amended exhibits has the complete list of the parties that were removed.
Oh, thank you. I'm sorry.
Yeah, sorry. I was trying to point that out, but it was hard with the back and forth. So on page 3 of that motion, the first paragraph, it lists all the parties that were removed, and that is Sabine Oil and Gas Corporation, Mountain Oil and Gas, Inc., JC Petroleum, Inc., Slover Minerals, LP, Holly B. Hansen, John Baxter Brinkman as the administrator of the estate of Virginia Brinkman, and John Baxter Brinkman. Those were the 7 parties that were removed since the original filing of the exhibits to this past Monday.
Okay, thank you. And then as to Exhibit 2, those people are still requested to be considered non-consenting parties, and there was no change submitted for Exhibit 2.
Correct.
So you were unable to locate any of those estates or estate people?
Well, part of what we do when if we find out somebody's deceased, we check the probate records to see if they filed a probate in Utah. Sometimes they will file a probate in another state, but not in Utah. And sometimes they're not going to file it in Utah because it costs too much money and it's not worth it for them to do that. So we have to kind of go by the probate ruling in another state, or explain to them that they need to do probate in Utah as well.
But you were unable to find anybody between the filing of the request for agency action on Exhibit 2 and enter into any leases with those people?
I did locate some heirs, but because some of these people, the one with 29 family members, I mean, we're talking about people who died back in 1940. That, you know, and you're trying to go through the airship and try to identify everybody. It's very difficult to do that, and an affidavit of airship does not transfer title. So I tried to identify who I could and contact who I could.
Okay, and I'm just trying to be clear about the type of notice and who were for. So would it be Axia's policy not to enter into a lease with a heir or a proposed, someone who's listed on your list of possible heirs who hasn't had a determination of heirship?
No, we do that. We will enter into it, you know, you'd want to talk to the family members a little bit and ask them. For example, one of these, we found one person and his father had died, and we said, well, how many children? And he said, I have a brother, a sister, and an adopted sister, which is very important. So that sometimes is sometimes family members won't recognize stepchildren or adopted children, and he was right up front. So yeah, we then tried to contact all of them as well.
But Exhibit 2 contains all of those people that you were unable to locate?
Correct.
Okay, that's very good. I appreciate the additional detail. There are some people who are listed on both Exhibit 2 and Exhibit 1. Can you explain why that is?
So there's the heirs of some.
Oh,
so it says the
yeah.
heirs of- grab that.
I got it.
Devisees, and we just included them both because we know, that's the estate, but we included them in the estates as well. There's really nothing different. It's just some crossover.
So I think one of the things that those original heirs, or the ones that are still on there now, heirs of,
Yes.
so I have tried to locate all these heirs, but it's not been all that easy. So I'm not, even though I may have leased some of these heirs, I don't know for sure if they're the only heirs or if there's going to turn out to be another heir. Until it gets probated, there's no way to know. So I have to keep this on here. These are heirs I could not find. And that's so they're on there for the interest I could not locate. Then we put them on the other estate to make notification, of course, that anyone in that estate, and then as I've identified these estates as we've gone down, when I locate people, I've added those estates too.
So if I can say back what I think you said, like, for example, the heirs or devisees of Perry A. Dustin and heirs or devisees of Kenneth A. Dustin, you don't have addresses for them. You've listed them on Exhibit 1, but you have also listed them on Exhibit 2, and it's just so that they get noticed by publication, and it could be anybody, is what you're saying.
Correct. Correct.
But you had specific people in mind for those heirs, and you tried to identify them and you couldn't.
Well, I'll give you I'll tell you about Perry Dustin.
I don't know if the board really wants to know.
So I tracked him down. He lived in L.A. He was married to Mabel. Then some woman comes out of the blue, family friend, who adversely is claiming his interest. Well, sorry, you can't just adversely claim somebody's interest. There's no estate. I've talked to Perry Dustin in Ohio, whose uncle that was. He hasn't seen his uncle or know anything about him. I don't know. We're never going to find him. We're never going to find his heirs. He's dead. His wife's dead. And this woman who's claiming adversely to be a family friend, so therefore she gets his interest, I believe she's dead also. So I'm never going to find them.
Okay, well, we don't want to try the patience of the board too much here, and we can't go through all these, but I
No.
think you've given us the evidence of your efforts.
Right.
But as to clarifying I think I still have so this is the substitute exhibit that was filed October 21st. And for Newfield, it says they have not made an election, not signed a JOA. So you're listing them, you're asking that Newfield RMI be non-consent.
Correct. That's their choice.
On Petro X, it says elected to participate, not yet signed a JOA, but you've listed them as also being non-consent.
To have a JOA imposed on them, but they won't be assessed a penalty because they elected to participate.
Well, we have to have a JOA imposed upon them. So they elected to participate, but if there's no JOA to govern operations, that makes it very difficult. I know you don't want to hear all the background on Petrox. That's a whole hour.
No, we don't. But I do need to know if they're going to be subject to a 300% penalty.
No.
That's the same.
So you view the force pooling to be a mechanism for requiring someone to sign a JOA?
Not to sign a JOA, but to be subject to how we're going to operate the well.
And if they had specific objections to the JOA, I guess they could have been here.
Absolutely.
And is that the same with International Petroleum Limited Liability Company? It says elected to participate, not yet signed the JOA.
Correct.
Have International Petroleum and Petro X paid the costs to participate in the well?
Not yet.
How much time are you allowing them to do that before they become non-consent?
Well, them not paying their bills doesn't have anything to do with them consenting or non-consenting. That would be that COPUS that we saw, Exhibit C, where we could charge them interest for not paying their bills.
So you would consider them which, consenting or non-consenting?
No, they consented, so they would not be under that non-consent penalty at all.
So Krenger, if I'm saying that right, has also agreed to participate but didn't sign the JOA. Have they paid their money?
No, not to my knowledge.
I think those are the only ones that are in that category. Are there any others that you should identify that have agreed but you haven't signed a JOA or haven't paid their money?
No.
Okay. Any other questions? I really do appreciate your knowledge and detail. Thank you. No other questions.
Board members, any questions for Ms. Gadd?
On Exhibit E, which is the JOA, Article 16, L2, both A and B, but A first, there's a fee for gas-related services of $1.15 an MCF. Could you explain those?
I'm sorry, where are we?
It's not.
It's Exhibit E, so it's the JOA that we're talking about.
We only have select pages.
David's going to get me the full JOA. Aren't you? I don't have it. I didn't bring it.
No.
16L. No, it's got to be right here.
There's no page numbers.
Yeah, I know. 13, 16. Is that in the COPUS you're talking about?
It's in Article 16, which is other provisions.
Oh.
It's pretty much close to the end.
This is for your gas gathering lines, your lines that you've got at the wells.
Well, I'm reading. She wants A and B. Oh, 2A and B.
So under L,
Oh.
gathering, transportation, marketing, lease fuel and water source and disposal. Under L2, under A, There's a fee for gas-related services of $1.15 an MCF.
Yes, that's to recoup some of the cost of those pipelines. Those gathering lines are incredibly expensive to put in place, and without them, you can't get anything to market. So the operator should not have to bear 100% of those expenses. The working interest owners who are bearing those expenses.
So does Axia own those gas gathering lines?
Correct. We
What
have
is,
the permits for them, we built them, we laid them, et cetera.
I understand. What is Axia recouping on the sale of gas at the marketing points it discusses?
We're trying to recoup the cost to get those lines in place. To get the permits cost money, the surface agreements cost money, the lines themselves cost money to lay, to bury, to do all that stuff.
Right.
So all we're trying to do is recoup some of that money
Right.
to get the gas to market.
I guess my question is, what do they sell the gas for? And is there any net value of that gas to the working interest owners that signed this JOA?
Yes. What they sell it for would depend on the price at the time it got to market. It's not always the same amount of money every day.
understand
So that would, everybody, all the working interest owners would get their share of that, as well as the royalty owners.
But they're paying Axia $1.15 to gather that gas.
Correct. Oh,
There is a fee for water supply of $2 a barrel.
we'll let you answer.
That's in B.
You want to take that? You were going to.
Sure. I'm going to add on the gas gathering fee. It's not always Axia. Axia goes to Kinder Morgan. Kinder Morgan charges us north of $1 to take our gas into their plant and get it to the big system. So it's really a pass on of what we're getting charged per MCF on our gas. On the water side, it's the cost of disposal, $2 a barrel. We have the right to dispose and handle theirs, or they can handle it themselves. But if we handle it, it's $2 a barrel, which is a standard commercial disposal fee.
Mr. Boulder, could we identify the witness?
I'm sorry.
Yeah. Can you state your name?
Taryn Frenzel.
On both of these charges, what is common industry charge for gas gathering and water disposal?
I can only say that on other JOAs, $1.15 has been the standard that we get from like Newfielder and Canas. So that's passed on. It's all the same, and that's pretty close to what we're getting charged with Kinder Morgan. On the water side, $2 a barrel is also we're actually paying $2.25. So it's more than current cost of disposing of water.
Thank you.
Mr. Moon.
Also in the JOA, there's that overhead charge of $1,000 or $10,000 for drilling, and then $1,000. I guess that's a month for operations. Is that irregardless of the size of the non-operator? Is that just a flat amount, or is that how's that calculated?
It's a flat amount.
It's a flat amount. Even if it's a very, very small non-operator, you get the $1,000 a month.
Right, because somebody still has to drive out there, pump it, watch it, take care of it, all that. So it doesn't matter if you own this much or this much, it's still the same thing. We still have to check it.
Okay.
Well, yeah.
And then I had a question. Have operators ever gotten together as far as finding these non-locatables? We have multiple companies out there, and there's probably duplicate efforts being done to find some of these hard to find. Has like the UPA ever considered having a database, or do you talk to other landmen from other companies and say, hey, here's my list of names?
No, we would all probably claim we're too busy to help another operator locate people, to be honest with you. One of the things I will do, though, is I'll go do a grantee run in the county, even though it's a tract index state. I'll do a grantee run to see if an affidavit of heirship was filed for that person with a different property, because that's not our property. It won't get picked up in our title opinion. Doesn't mean it's not out there. So if I go do a grantor run and I find, oh, look, there's an affidavit of heirship, let's start there. That's another resource we use. And typically those affidavit airships get filed because other oil companies make them file them.
Okay.
So in that respect, we do kind of help each other out through those.
One more question. What is Axia's working interest ownership in this drilling unit?
And I got it right here. Right now, as of today, it's 74.081002%.
Okay. And who's the next largest? Or are there just a lot of them?
Let's see. I guess Mountain Oil would be the next at 5.47, Finley at 4.61, and then a couple 3.9. Nobody else is even close.
Okay.
This was something that way back in the 80s, where multiple, like I said, we started off with 29 working interest owners, just trying to identify some of these. Most of them were Canadian companies, so I was looking all over pretty much the United States and Canada and Pennsylvania and Texas and everywhere else to locate, and I did actually locate them and got them to convey to us. So.
And these, say, top 2 or 3 or 4 working interest owners that have signed the JOA, is it basically this JOA, or were there
Yes.
different terms
No.
negotiated?
No, it's
very
yeah, pretty much.
JOA with
Yep.
the $1.15 and the $2
Yeah.
on the
Yeah.
water? Okay. Okay.
I just want to make one point of clarification on the overhead charges, the 10,000 and 1,000. So that's proportionate to their ownership interest. So that's
It
the
is.
total. Yeah, I want to clarify. So that's a total that Axia collects, but divided up proportionately by the owner's interest. It's not everybody. You own a little piece. You have to pay the
pay a little
same as
piece,
somebody who
right.
owns
Okay.
20%.
20%.
Yeah. So just want to make that clarification.
Other questions? Go ahead, Steve.
What is the current percentage of the unit now that is leased or agreed to join unit? I know that probably changes from month to month, but what is it currently?
Currently leased, or I'd have to get a calculator.
All participants are leased. And in other words, the percentage of those that will be subject to the non-consent, on the other hand.
So I believe it's around 93, 94% now. I think when we originally filed, it was around 89, and we just keep getting leases in or mineral deeds or finding a working interest owner who agreed to participate.
Right, but it's somewhere between 93 and 94.
Yes.
Other questions from the board? Thank you, Ms. Gadd. Oh, sorry, Mr. Alder.
Oh, thank you. A follow-up to the board's questions, just briefly. With regard to these Article 16 modifications to the JOA that were asked about, do you know if those are the reasons that Krenger and Petrox and the other companies that you mentioned have not been willing to sign a JOA?
No, that has absolutely nothing to do with it. Petrox, this guy told me he doesn't understand a JOA, he's never going to sign one. So I said, okay, you don't have to, but he wants to participate. Krenger was an unleased mineral interest, actually, who then decided to participate. And I'm not sure why he hasn't signed it. And who was the other one? Newfield, did you say?
No, I don't remember they were in Exhibit 1.
Yeah.
As
I think
revised.
Newfield was one in IP, and they just...
International.
I'm sorry, International Petroleum. And International Petroleum never signs one, and Newfield has been sold to Encana, and I'm not sure Encana will sign one either. So I don't understand it. It makes no sense to me. It's going to be imposed upon them. I don't know why they wouldn't sign one. It's just their company policy.
And just for the record, just to clarify, your participation and ownership. The request for agency action, paragraph 4 says that Axia owns approximately 73, this was at that time, 0.481172% of the working interest. And then you refer to other parties who have agreed to participate but have not yet signed a JOA or tendered their proportionate share of the FA, and you refer to PetroX International and Cringer, and then it says the total interest voluntarily joined to the drilling unit would be 89.34480%. That's the percentage that you now say is about 93.
Yes, because since that filing, for an example, Mountain Oil has signed a JOA, so they got removed, and then you would add their interest to that 89.
So
Does that make sense?
So they're only being forced pulling for the purpose of signing the JOA.
Correct.
Okay, thank you. I appreciate your indulgence. No other questions.
Thank you, Ms. Gadd. Mr. Bolder, you may call your next witness.
I'll change.
Mr. Frenzel, can you please state your name and business address for the record?
Karen Frenzel, 1805 Shea Center Drive, Highlands Ranch,
And your current position with Axia?
VP of Completions and Engineering.
Okay, Mr. Frenzel has previously been recognized as an expert in petroleum engineering in various spacing and compulsory pooling requests, including the one just prior to this and cause number 139-166. With the consent of the division, I'd like to ask that he be admitted as an expert in petroleum engineering for purposes of this cause.
No objection.
Board members? You are continually recognized in this hearing as an expert witness in petroleum engineering. Thank you.
Okay, we have only one exhibit for Mr. Frenzel, and that is Exhibit F. Was this prepared by you or Axia personnel with your supervision and review?
Yes.
Okay, can you please explain with this exhibit?
Yeah, this is a AFE for this particular well in this area. And as you can see, his total should be $10.6 million for these wells.
Could you speak close to the microphone, even turn the microphone with your hands?
Okay. $10.6 million for these wells.
Okay, and this contains also contains the dry hole costs versus the completion costs. Is that correct?
Yes, about $200,000 for dry hole. Or no, dry hole is going to be 3.9.
Right. And in your expert opinion, are these costs fair, reasonable, and necessary?
Yes.
Can you briefly discuss the risks associated with these types of wells in general and this specific proposed well?
Sure. These are long laterals, deep, very high pressure, 0.83 psi per foot reservoir pressures. So a lot to deal with. Any small problem becomes very expensive.
And has Axia drilled any long lateral horizontal wells in this drilling and spacing unit?
Yes.
In this particular unit?
Mm-hmm.
Okay. In your expert opinion, when considering the amount of risk involved and the other reasons outlined by Leslie, is a 300% non-consent penalty justified?
Yes.
Okay, that concludes my examination of Mr. Frenzel.
Division.
The division has no cross-examination for Mr. Frenzel.
Board members. Steve?
This may be related to the JOA. Is there a cash call in the JOA for the amounts of what, the entire well, or for the drilling costs only?
For the drilling costs. So if there's dry hole costs on here, that would not be part of the cash call to drill the well. But yes, we do cash calls for the most part.
And
But when you've got an interest this small, you know, it costs more money almost to do a cash call than, than you're going to get.
that cash call, you're looking for the entire cost of drilling and completion? No. That's what I talked about dry hole. I mean, just for the drilling and then for the completion, are they lumped together or is there a separate?
We generally do a cash call for the drilling only, and then because completions will start later, I think it's 30 days before completions, we'll do a cash call for completions.
Very good. Thank you.
Other questions?
Just to follow up on that, so on the drilling or the dry hole costs, how far in advance do you typically cash call that?
It's 30 days, whether it's before we build the pad or spud the well, but it's 30 days generally in advance notice.
Okay, where does that leave us, Mr. Bull? Does that conclude your,
Yeah, that concludes my presentation. We can move for admission of exhibits. You can, however you want to proceed. If the division wants to go before admitting the exhibits, that's fine as well.
we'll go back to the division, thank
I
you.
think we'd be happy to have the exhibits admitted, and the division supports the request, so we don't need to come back to us for that.
Okay, thank you. All right, let's move forward with the admission.
I guess I would like to just clarify, and I think it has been clear, that in the order, we need to identify those parties who are considered consenting except for the JOA. Be clear about that in the order, and I'm sure Mr. Bolden will do that.
Absolutely. So I would like to move for admission. We can go through this list here. I think I've got them all ready to go. Amended Exhibit 1, Exhibits 2 and 3 to the request, Exhibits A through F, Amended Exhibit G, Exhibits H through Q, Exhibit S, and the reason why it's H through Q and then S, at the time we submitted the exhibits, we had one exhibit mislabeled. It was Exhibit R. We removed that instead of trying to renumber all the exhibits. There's no Exhibit R. Exhibits Y, Y, and Z.
And S is in Sam, you said earlier, is that correct?
I'm sorry, can you repeat that?
S is in Sam?
Yes, correct.
That is in agreement with my record, so.
Yes.
Those exhibits are so admitted. Thank you. So we're back to you for summation, Mr. Bolda.
Yeah, just briefly, I believe that the statutory and regulatory requirements for granting this request have been met, then that the relief is fair, reasonable, and justified. And I thank you for your time.
Thank you. Board members, are we prepared to make a motion, or would you like to deliberate for a bit? All right. We're going to go off of the record and probably take 10 to 15 minutes, and we will return. Thank you. Okay, we are back on the record. We're going to proceed as follows. I'm going to ask Mr. Moon to ask a couple of final clarifying questions. And then based on the answer to those questions from the proponent, we may have to go back into recess. So he will ask those questions and we'll move from there. Thank you.
So on page 3 of the request for agency action, on page 3, item number 3, there's a request that we declare Axia the operator on behalf of itself and other parties who have voluntarily joined the subject drilling unit as consenting owners. What is the need for that request? Because consenting owners have already signed a JOA which declare Axia the operator. So what's the statutory basis for that, and just in general, why is that necessary?
Right. So the reason for including that is it's on behalf of Axia as the operator and the consenting parties as non-operators. They've all agreed Axia is the operator, but these parties that we're pooling or asking to be pooled have not agreed to Axia as being the operator. So that's why, and in the JOA, that we're asking to be imposed upon the non-consenting parties, it lists Axia as the operator. So it's the board confirming, yes, Axia is the operator for this well.
Okay.
And it's also something that to my knowledge, has been included in all the other force pooling requests, not just by Axia, but others.
Okay. Any concerns with that division? Any thoughts?
I think not. I think that they are the operator as that term is used for purposes of the well. I think that as we get into the rulemaking and talk about operatorship and the effect of this order on subsequent wells, it may have some concerns, but I think we can deal with those later. I agree this is probably an interesting question that hasn't been raised before, but I don't think the division has a problem with it.
Okay. Thank you.
Okay, I'd like to make a motion that we approve this request for agency action. Now, Steve, you had a stipulation that I want to make sure that we're clear on. This is the stipulation until the rule is in place, right? And this is just this well, correct? Am I correct, David?
As to Axia,
Subsequent well.
as to Axia being the operator.
Correct.
Correct. Yes. That we're just making it applicable to this well,
Right.
and this order is subject to the statute addressing subsequent wells and the future rule that's put in place.
With that understanding in place, I'm willing
Steve,
to.
didn't you have another concern about people who had agreed only for purposes of the JOA that you wanted stipulated?
I think I don't know that it's stipulated. I think it will be yes, I think it should be a stipulation, I guess. It will be in the order. I think Mr. Bolden and I understand that there were 4 people who have been identified as agreeing to participate but having not signed a JOA, and apparently Axia is not concerned as to when they will pay, but we need to clarify they are not being force pooled as to the JOA, but so they're
No non-consent penalty.
Yeah, I'm sorry, I said it the wrong way.
Yeah.
Yeah, no non-consent penalty, but they are being forced to be subject to the JOA. I think Mr. Begley understands that.
Susan, is your motion to approve the agency action with that stipulation?
Yes.
Okay, is there a second?
Second.
All in favor, say aye.
Aye.
Aye. Let the record reflect the voting was unanimous. Mr. Bulla, would you please prepare the order?
I will.
Thank you.
Thank you.
Thank you all. Sorry.
Mr. Chairman, would you please read item 3 into the record?
Yes, I will. Yeah, I'm going to do that next.
Did you confirm all the exhibits?
I don't know what yeah, we did that. We admitted them. That's all I need. Thank you. Okay, we are to the final agenda item for our hearing today. It is agenda item number 3, docket number 2019-021, cause number 13-168, in the matter of the petition of Vetar Energy GP. It is my understanding that this item has been continued to the December 1st or December board meeting. Can you just confirm that, division?
Yes, that's the division's understanding as well.
Thank you.
And so work's being done on this, is that correct? Okay, and then, so the division will report to
Yeah,
us.
the division will report to us in December on this matter further.
Have you already been working on this, engaged in it, or you have? Good.
No, I'm not sure I was paying enough attention. I thought you were reading in the, the compulsory pooling.
Nope, the Riviera.
Oh, the Riviera, yeah, okay. My apologies. On that one, yes, the division has been working and talking to people. There was some question, and it would be helpful to have it clarified that whether we had to report to you by November 14th. That's 60 days from the date that it was filed. We would prefer, since it's continued to December, to report to you at least in advance of the December hearing, so you know what's going to be on the December hearing.
That's fine.
Okay, thank you.
That works.
I apologize. I was already thinking of my lunch. I should have paid more attention.
Okay, given that, I would entertain a motion to adjourn.
So moved.
All in favor? Aye. We are adjourned. Thank you.